for this, the very first panel, dealing with the legal context of 1916, both of our speakers, Dr. John O'Dowd and Dr. Thomas Moore, are members of the School of Law at University College Dublin, though actually Thomas began here as a legal science and history student when I think it was still University College Galway. Yes, just about. Okay, so we're going to begin with John's paper on the legal justifiability and justifications of the Rising.
And thanks very much for the invitation to speak at what people have already rightly described as a very interesting seminar. So I told my taxi driver yesterday that I was to give a paper this morning on whether the 1916 Rising was legal. And his answer was obviously no, and it would be tempting just to stop there. The illegality of the Rising from the perspective of the law of the United Kingdom is obvious, although the late Mr. Justice Adrian Hardiman and others have documented the difficulties that General Maxwell and his subordinates encountered when attempting to establish exactly what type of offence had been committed by the rebels and the correct way of proceeding against the offenders. It's also a commonplace of discussions of the Rising going back to at least the 1960s, and often repeated in recent years and months, that this legal system against which the rebellion was mounted was one endorsed, at least to a substantial degree, by all the elected representatives of Ireland in the House of Commons, and in particular by a constitutional nationalist party that until a little over 18 months before the Rising had enjoyed a pivotal role in the legislature of that state. There's no point, therefore, in examining the legality of the actions of the rebels, I think, from that point of view, although there are some nuances that are worth exploring later on. If the Rising is to be judged legally justifiable, it must be either in terms of international law, as it then stood, or at least for its interests in terms of legal theory as it does today, or perhaps from the perspective of an alternative theory of legal justification on which the men and women involved in the Rising based their own actions. The international dimension I'll leave until the latter part of this paper, and then largely as an aspect of the thinking of the leaders of the rebellion themselves. Nor should I stress it my intention to offer an argument as to the moral justification of the Rising, a question which much preoccupied its leaders, as it has their critics and apologists ever since. Given the particularly clandestine nature of the planning of the Rising, I think we have two main types of source for their constitutional thought, if that's not putting matters too highly. That is, of the leaders and in particularly of the signatories. The first is the proclamation itself, which is worth some exegesis, and the other is the statements they issued in Easter week and recollections of the discussions that took place in the GPO, particularly those alleged to have taken place in Desmond Fitzgerald's memoirs. It's broadly agreed that the proclamation itself is not an exercise in constitutional design or a particularly clear or coherent expression of a philosophy for the organisation of a state or a legal system. Indeed, it's fairly evident that this was not the purpose which the proclamation was intended to serve. The central claim to legitimacy that we find in the document is that the Irish nation has an inextinguishable claim to independence, in practice understood primarily as separation from England, it seems, that cannot be extinguished by acquiescence in any other form of government, even if this is the will of the majority of the people and their elected representatives. As has frequently been pointed out, the step in the argument that's evaded in the proclamation, very deliberately, is the authority of the group behind the Rising to act in the name of the Irish people in this way. Before moving on to that question, it might be noted that this central claim of the proclamation was repeated and elaborated upon in the Declaration of Independence adopted by Dáil Éireann in 1919. Unsurprisingly, the claim to legitimacy made in this form, I think one could say, goes underground in the Constitution of the Irish Free State 1922, which refers in much less explicit terms to the sovereignty of the people of Ireland, but not in quite this emphatic way that that sovereignty reflects the more primordial sovereignty of the nation, meaning something else. At most, one finds a very attenuated form of the claim underlying the Rising in, for example, Chief Justice Kennedy's dicta in O'Fowler versus McLean, where he says, "Our Constitution was enacted by an Irish Constituent Assembly," he's speaking of 1922, of course, "for a people conscious of an historical national identity preserved independently of any particular state organisation during its long struggle for at least a spiritual existence." So in the 1920s, in Kennedy's thought at least, this idea of the right of the nation to strike for its freedom is expressed in somewhat less drastic terms in the proclamation. With the Constitution of Ireland, something more recognisable as the claim made in 1916, I'd submit, though, is restored to a central place in the legitimation of Irish national political life. For in Article 1, the Irish nation affirms its inalienable, indefeasible and sovereign right to choose its own form of government, to determine its relations with other nations, and to develop its life, political, economic and cultural, in accordance with its own genius and traditions. The Declaration, of course, contained in Article 1, sits atop a charter for democratic government, which includes, not coincidentally, the emphatic provision in Article 6 that the powers of government created by the Constitution are exercisable only by or on the authority of the organs of state established by the Constitution. That brings us back to the question in 1916, I think, of the basis on which the few hundred who took part in the Rising, none of whom had any electoral mandate, claimed to be constituting themselves as a provisional government, exercising all powers of government in civil and military affairs on behalf of the people of Ireland. A variety of perspectives on this specific question have been expressed in treatments of the justifiability of the Rising. One aspect is undoubtedly the influence of the culture of the Irish Republican Brotherhood and of certain key representatives of the Brotherhood on the way of proceeding adopted by the small group behind the Rising. It's well known equally that the Rising was the work of a minority within the IRB itself, carefully concealing what their plans were from those of their colleagues such as Bulmer Hobson, who considered that armed action in these circumstances without clear popular support would be a breach of the IRB's own constitution. On one hand, therefore, the constitutionalism of the IRB, based on the notion that the organisation held a trust for the Republic of the future, cannot securely be relied on to explain or still less justify what those behind the Rising attempted. On the other, the disagreements within the IRB may well have been coloured as much by pragmatic assessments, by Hobson and others, of whether an armed rebellion was opportune at that particular point, than by the more abstruse aspects of Fenian doctrine. What's certainly true is that the Fenian mindset provided a way of making sense of what they were doing on behalf of the state that was to come for those who launched the Rising, however far that future state may have been in the future. It's been also argued by many people that the type of nationalism embodied in the claim of this small group to rule as the vanguard of the revolution, influenced as it was by trends in constitutional nationalism rather than by its liberal democratic variety, prefigures the rise of fascism in Europe over the following 20 years. And in the same vein, it's been suggested that 1916 inaugurated almost a decade of, in one form or another, military dictatorship and civil war, something that became explicit in varying ways in 1922 to 23, but was implicit in the logic of 1916 from the start. And of course, the references to statements made by various anti-treaty IRA figures in terms of their rather nonchalant attitude to the allegation of a military coup or a military dictatorship is evidence of that. Despite the indirect nature of the IRB's responsibility for the Rising, it was, of course, quickly marshalled by Kathleen Clarke and others, and it did play a significant, if not still entirely clear, role in the freedom struggle right up to 1924, it could be argued. For instance, as John Regan has pointed out, the group withdrew its recognition of the legitimacy of the Dáil government at the beginning of 1922, and the split in the IRB was certainly a complicating factor in the dispute over the treaty and in Michael Collins's own ambivalence about the relationship between the civil and military power right up to his death. Arguably, it was only with the quelling of the army mutiny in 1924 that this whole period, this whole episode, came to a final close. Against that, it has to be accepted that the leaders of the Rising do not appear to have given much, if any, thought to how they would govern the republic they proclaimed, given the slim chance that its civil authority could ever be exercised in a meaningful way. As with the nature of the proclamation itself, it's probably a mistake to consider them as setting out a blueprint for a new state when the deed at which they aimed was of quite a different kind. The lack of immediate political reality to what they were undertaking is also reflected in the platitudinous quality of those parts of the proclamation that touch on the civil affairs of the Republic. In particular, the reference to cherishing all the nation of the children equally has to be read in the context of Pearse's expectation only a few years previously that the Irish Volunteers and the Ulster Volunteers might end up fighting side by side against Crown forces. That's not to say that those involved in the Rising, as has been pointed out earlier, didn't have views, sometimes quite specific ones, about the governance of a future Irish state, merely that these were more tangential to the Rising and the proclamation than is often assumed in retrospective assessments. These sometimes diverging aspirations for a future Ireland may have motivated them to participate in the rebellion, but they didn't amount to a coherent programme that they collectively agreed upon. As many have suggested, it's the democratic programme of Dáil Éireann that has a better claim to that distinction, especially given the input of the labour movement into it in a more meaningful way, perhaps, than Connolly contributed to this aspect of the rising. Even if the provisional government were a military dictatorship in principle, it's unclear if it was ever part of the plans of any of those involved to play that role in reality. That said, the IRB element in the leadership may have been more inclined to such authoritarianism, and as Ruth Dudley Edwards points out, it appears that Tom Clark would actually have preferred John Devoy to Pearse in the role of President of the Government of the Republic, with all that implies for what kind of republic that might have turned out to be. What then of the other dimension, that of legitimation in the eyes of the international community? The appeal to world opinion was certainly a prominent feature of the activities of those who planned and executed the rising. However, it's important to remember that in 1916, the principle of self-determination was not yet an established part of international law, and even the Wilsonian articulation of it lay over a year in the future. If there was an appeal to world opinion, it was really to this notion of an inextinguishable claim to national freedom of the kind that I mentioned earlier. One of the historical sources of the modern notion of self-determination, but by no means an identical concept. This was therefore very much a rhetorical argument, even relative to the still fairly nebulous character of self-determination in the present day. Insofar as the 1916 leaders looked forward to a peace conference, it was to one at which the Central Powers would be dictating terms to the defeated Allies, and at which it would be in Germany's interests in particular to guarantee an independent Ireland as a check on Great Britain. It seems clear that they, or at least some of them, understood from Plunkett's conversations with the Germans that 3 days' resistance would give them the status of a belligerent, in the sense that they would be entitled to call on a victorious Germany's aid at the conclusion of the war, and that this is the main significance they placed on reaching that particular milestone. There's a caveat necessary about the reliability of Desmond Fitzgerald's disputed recollections of what was said in the GPO on this subject during Easter week. However, if even partially true, the speculation about Germany's strategic interest in an independent Ireland, hostile to Great Britain, the appropriateness of accepting Prince Joachim as king as a means of cementing this alliance, and the prospect of succeeding Hohenzollern monarchs adopting and championing the Irish language, does suggest a mindset far removed with the concern for establishing Ireland's claim to self-determination in anything like the modern sense. It's equally true that even if such conversations took place between some of the signatories and their associates, they clearly did not reflect the views of the entire leadership, whether Irish Citizen Army or Irish volunteers. Clowney-Nail and Devoy, of course, provided another layer of opportunistic pro-Germanism, as did Casement's fruitless adventure, which he later so strongly disavowed. It has been suggested that the republicanism of many of those involved in the rising was fairly superficial. That is, it was anti-monarchical because it was Anglophobic. Fitzgerald's recollections of the discussion of importing a king from Germany would tend to substantiate this. However, even if we leave that somewhat dubious episode to one side, there's still room for substantial argument on both sides. It's true that the values of republicanism were not clearly articulated or explored in its use as a synonym for complete separation from England. On the other hand, to suggest that within this group there was a complete lack of intellectual engagement with the civic values or principles of justified government that are the concern of Republican thought would be equally false. As mentioned earlier, what seems a more reasonable conclusion is that the individuals and groups who coalesced to bring about the rising did have quite strong and carefully thought out positions on many of these questions, and they were in large part motivated to take part in the rising because of these beliefs and values, but these were not really features of the collective enterprise of the rising itself, either in the proclamation or anything else that they did during those few days. The peace conference that did follow, of course, was of quite a different character from the one that the 1916 leaders looked forward to, and it unceremoniously rebuffed Dáil Éireann's representatives. Part of the reason for this was Woodrow Wilson's own lack of sympathy for the Irish cause, a particularly serious problem given that in the course of the Paris conference no one could quite understand what self-determination meant, and it often appeared to resolve itself into a question of what Wilson himself thought just and proper in any particular situation. What is of most interest, however, are Wilson's reasons for opposing consideration of Irish claims at the conference. And I quote Margaret Macmillan's study of the Paris conference here. When a delegation of Irish nationalists, nationalist Irish rather, asked him for support, he felt, he told his legal advisor, like telling them to go to hell. His view was that the Irish lived in a democratic country and they could sort it out through democratic means. In broad terms, President Wilson's sentiments reflect contemporary international standards in relation to the exercise of the right to self-determination, as found, for example, in the Badinter Principles or in the Supreme Court of Canada's secession reference decision. Indeed, Anthony Whelan has pointed out that the case of Ireland from 1916 to 1922 leaves the modern Irish state in a potentially ambivalent position when it comes to urging compliance with the Helsinki Final Act or with the widely accepted approach to secession as represented by the opinions of the Arbitration Commission of the Peace Conference on Yugoslavia already mentioned. In addition, under customary international law in relation to the rights and duties of states, widely acknowledged to be accurately stated in the Montevideo Convention, it does not seem that the Irish Republic could have been a state, whether anybody else recognised it or not. Because under Article 1 of that convention, the state as a person of international law should possess the following qualifications: A permanent population, B, a defined territory, C, a government, and D, a capacity to enter into relations with other states. The transient regime established during Easter week hardly satisfies any of these characteristics. Even in the case of the third, the rebels were really only enacting the pretense of being a government. One aspect on which the rebels were punctilious was in relation to establishing their status as belligerents, acting in accordance with the law and customs of war as, at least in principle, a uniformed force with a conventional command structure and eschewing any unlawful means of warfare. The allegation, for instance, that the rebels had used dum-dum bullets was a particularly incendiary and unsubstantiated one that emerged against them in the immediate aftermath of the rising. The commanders of the rebel forces may have been attempting, though I have no evidence that they were conscious of this, to sidestep any argument over the scope and meaning of the Martens Clause in relation to the Hague Conventions and subsequent treaties on the laws of war. Because it's certainly the case that if the rebels' German allies had to deal with similar armed resistance, and they deemed those involved in it to be franc-tireurs, they would have been treated with much greater severity than General Maxwell meted out in 1916, even if the initial official acquiescence in Captain Bowen Coulter's rampages might suggest otherwise. So even if the concept has no direct application, part of the rebels' concern with their military status seems to have been to avoid designation as unlawful combatants. The British Army, of course, did not accord the rebels combatant status. For one thing, any attempt to negotiate terms was resisted and unconditional surrender was required. For another, the rebels were treated as criminals, albeit under the special regime laid down by the Defence of the Realm Acts. And General Maxwell was adamant, for instance, that any executions by firing squad rather than by hanging were humane concessions rather than a matter of right, although probably they were more military practicality rather than anything else. The fact remains, however, that such a distinction was accorded to the 15 executed in Dublin, although not, of course, to casement. Furthermore, it's well known, I think, that when communicating with Maxwell over how the executions might be brought to an end, and in response to his statement that there might be further executions in case of proven murders of soldiers and police, the London government replied that the Cabinet assumed that by proven murder, you mean special cases other than death in the ordinary course of fighting. In all such cases, the charge should be in terms one of murder. There's also Brigadier General Blackadder's notorious response to his experience of presiding over Pearse's trial. He is reported as expressing his regret at having to condemn to death one of the finest characters I've ever come across. There must be something very wrong in the state of things that makes a man like that a rebel. So clearly then, at some level, their enemies psychologically accorded the rebels the combatant status that they were formally, officially denied. The image of honourable and lawful military conduct, bearing and demeanour, which impressed friend and foe alike, was obviously a contributory element in the myth of the Rising, if only as an aggravating factor in relation to the revulsion and anger that the executions and other aspects of the captured rebels' treatment caused. So the proclamation then is disingenuous in its reference to Ireland having organised and trained her manhood through her secret revolutionary organisation, the Irish Republican Brotherhood, and through her open military organisations, the Irish Volunteers and the Irish Citizen Army, when the Rising was in fact the work of a clandestine minority in both of those first two organisations. The reference to the volunteers, who were themselves in 1916 the rump of the initial mobilisation of 1913-14, might in closing lead us to some further reflections. As well as being open, the volunteers could also be considered to be a constitutional organisation in some sense, even after the split following from the outbreak of the war. The initial genesis of the volunteers, after all, was as an armed group supporting constitutional government in Ireland and the enactment and implementation of Home Rule as adopted by the Irish Parliament. In that regard, the movement spanned the political spectrum of Irish nationalism, although some of those on the separatist end certainly participated with a view to turning the force to their own ends in the longer or shorter term. Pearse, it should be said, does seem to have been perfectly sincere, as was mentioned earlier, if for his own idiosyncratic reasons, when he promoted Home Rule and advocated that the volunteers act in support of Redmond in achieving that goal. Even after the break with Redmond and the National Volunteers, the remaining Irish volunteers represented a spectrum of opinion, much of which was neither Republican nor unambiguously separatist. However, those behind the countermanding order, notably McNeill and Hobson, were prepared to contemplate armed rebellion in the event that moves were made to suppress the volunteers, or if the threat of conscription radicalised public opinion to such an extent that what one might call a defensive rising would have had a substantial degree of popular support. As Charles Townsend points out, it was in fact the conscription crisis that provided Sinn Féin with critical political impetus in 1918 and finally wrecked the prospects of the Irish Party. And the threat of conscription had probably receded rather than increased as a result of the rising 2 years earlier. Had Bulmer Hobson, been involved in the direction of a rising of that sort, the tactics employed may well have been very different, and the scale of the fighting much greater and more prolonged, if more dispersed. A rising of that kind would have raised issues of legal justification and justifiability of a significantly different kind from the one that did occur, and perhaps also of greater substance and interest. For the men behind the rising that did take place were not greatly concerned with justifying their actions in the sense that legal or political theory can easily deal with. Their rising was a desperate act, preoccupied with how the deed was done, not with its immediate practical consequences. And as most would concede, that is what ultimately proved to be the secret of their success. Thank you.